America's top court is once again debating the balance between race, representation and the right to vote in a case that could reshape the foundations of U.S. democracy. The Supreme Court's Louisiana case may well determine the future of voting rights across the USA. Take a look at our next report.
This isn't just another courtroom battle. It's a defining moment for American democracy. At stake is a core question. How far will the United States go to protect the idea that every citizen's vote counts equally, regardless of race? At the center of this legal and political storm lies the Voting Rights Act of 1965, the landmark law born out of the civil rights movement. It was designed to end decades of racial discrimination in elections and to guarantee black Americans, especially in the Deep South, the right to vote freely. Nearly 60 years later, that very law is back before the US Supreme Court, where the conservative majority now seems ready to redefine or to weaken the key protection. The case comes from the state of Louisiana, which has 6 congressional districts and a population that is roughly one-third black. For years, only one district was drawn where black voters formed a majority, effectively limiting their political voice. Civil rights groups sued, arguing that Louisiana's map packed and cracked black communities and diluted their voting strength, violating Section 2 of the Voting Rights Act. A lower court agreed, saying Louisiana's earlier map gave the shrinking white population just 58% control over 83% of the districts. The court ordered the creation of a second black majority seat. What Section 2 does? Section 2 is the heart of the Voting Rights Act. It prohibits voting laws or maps that leave racial minorities with fewer opportunities to elect representatives of their choice, even if no explicit race intent is proven. After the Supreme Court in 2013 struck down another key part of the law in Shelby County versus Holder, Section 2 became the last major line of defense for minority voting rights in America. At the core of the conservative argument is the Equal Protection Clause of the 14th Amendment, the constitutional promise of equal treatment under the law. However, the case has national implications. If the Supreme Court limits Section 2, states could redraw up to 19 congressional districts, many in ways that would benefit the Republican Party, which currently holds a slim majority in the U.S. House of Representatives. The bigger picture: if the justices decide that race can no longer be used as a corrective tool in redistricting, it could end decades of precedent and shift the national conversation from protecting minority voter power to enforcing a colorblind interpretation of the Constitution, even when outcomes remain racially unequal. That would mark a fundamental rethinking of how democracy ensures fairness in a multiracial nation. Nancy Baloda's report for DD India.